shirt on, and she says, oh, I think you're right, Samir. I said, no, 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 my son. So he takes after his mother, vote for him, it's okay.
You need me to join? I'm gonna.
Yes, I know.
Please get in.
I talked to
Do you want me to test it?
Is it permissible for me to set up?
Yes, yeah.
Well, then 20 years ago.
Are you the
wasn't it?
first or case?
I hope so. My name's up there
Yep,
first.
yep.
Yeah.
Yeah. You guys are the first case too?
Yes, down.
Okay.
Shawnee County.
Nice to meet you, sir. Well, you might take that under advisement. Most people,
I'm sure I will take it.
Yeah, I noticed the day when I walked in, it said 1976 on the cornerstone. And I thought, that's the year I was born.
Yeah, like I said,
I'm
you're
really
really
old.
old. So,
Huh?
like you said, it was gonna be the year you were.
Oh, no. No.
Test, test.
Just trying to
That's
get
an old
my
one.
50th year. Practicing.
You know what I'm saying, the same thing. I don't know, they're gonna want me here.
Test, 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 test. I don't hear myself. Oh, because it's a delay.
My assistant, 25 years.
Test, test. There, yeah, I can hear it.
Well, the real problem is the MICT.
Okay.
There's only a 1 in 5
Yes.
chance.
It is gonna be thrown into this one.
So-
I think it's less than
Oh,
that.
Oh, you talked to her, right?
Called.
Yeah. Anyway, these are new chairs, I'm told. So you can bring in new chairs.
No.
You got 50 years coming this year.
Is that just
Yeah.
one? That's just, you're just watching. You don't have to have that up.
76, 26, yeah.
Right, yeah, I gotta get this.
49.
27.
I'm sorry, what?
I gotta get to 27 and I'll be
Yeah.
with you.
Yeah, no, it's been so,
So we're live on YouTube.
ooh, live from Topeka, Kansas, YouTube. I've written a new bar show.
Oh, did she say she?
Try to get Speak the Bar to underwrite it.
I was resting. Yeah.
Yeah, we haven't done one here since 2019. Finally got those stated.
She's good? Okay.
So now I just gotta get some other people to approve it.
Oh, I'm just looking.
Sounds like you're
Looking for my colleague.
Well, they're on vibrate.
Whatever, I just should be able to, I turned mine on.
Yeah. Okay, good.
You can see most times that
So which one of you is making the argument? Oh, that's it. That's it.
We're going for the.
Put
sympathy.
beauty in front of age.
Yeah, right.
That's it. I got it. Okay. It's a good strategy.
Well, now that I see you, it's a great set.
Yeah.
Can I message you, like, if I notice the sound goes out?
Yeah.
Okay. Travis?
Doc Rose.
Yeah.
Okay. Or do you want me to?
Yeah.
I'm not opposed to it. I know what you're trying to do, so.
Just don't cry.
You said Doc Rose. That was like. Travis Rose. No, that's fine.
Richard and the.
That is definitely.
Having been harassing judges for almost 5 decades.
Yeah. Yep.
Is your computer sound on?
Yeah, I already.
Okay.
Yeah, sometimes the mics shut off. I told him to watch this. That I shouldn't. So I have it set up. I'm gonna watch for minutes.
You checked his work status. We checked his work status. I think there's one after.
There he is, we're just waiting for him to leave.
Oh, okay. All
We
right.
got it, Mike.
Thank you for the courtesy.
We're at least gonna let you go to court.
By the way, we still gotta get our road name.
Yes,
The
sir.
library. She's, the library is agreed.
Yeah, I actually. I don't know if that matters. It's city.
It's a city. I've already talked to this.
Well, I talked to him three times a week, so thanks for
I think it's what
that.
we need to do is, one of the issues I'm supposed to contact the heirs. Years ago. So I dropped. So now there aren't, is a,
Yes.
You have some more houses.
This isn't that big.
we're one of the few groups, you know, it used to be lawyers are allowed to be civil with each other, except during argument. So is that okay? All right, as long as he's not a client. He's
I know.
talking to his lawyer.
Yes, yes.
But when it's over, when it's over, he's a pretty good guy.
Yeah, I know he goes. All right, let us know when it's time.
All rise.
Please be seated. Good morning, everyone. Welcome to the October docket of the Kansas Court of Appeals, sitting here in Topeka. I'm Judge Tom Malone. To my right is Judge Angela Coble, and to my left is Judge Sean Hatfield. He's an assigned district judge. He's helping our court for this docket. We will be the panel for the cases today. I'll call the cases in the order of the published docket. When I call your case, you can come forward. I see the first counsel's already here. We'll get your appearances and then proceed with the hearing. Just a brief orientation. I remind you that we have read your briefs, so we're familiar with the facts of your case and what the issues are. You might keep that in mind as you make your argument. As presiding judge, I'll be the timekeeper. We've got the clock right here. Each side is given 15 minutes for your argument unless it's designated differently on the docket, and I think this first case is a 20-minute case. They're usually 15 minutes. The appellant's attorney should let us know in advance if you wish to reserve any time for rebuttal. And if there's more than one attorney per side, you need to decide in advance how you wish to split your time. After the arguments today, your case will be deemed submitted for decision, and we will take the case under advisement and get a written opinion out to you and your clients just as soon as we can. So with that, I'll call the first case on the docket. It is from the Board of Tax Appeals. It's number 127-431, entitled In the Matter of the Revenue Neutral Complaint of Kenneth L. Corbett in Shawnee County, Kansas. Shawnee County is the appellant, and who do we have arguing this morning?
Good morning, Your Honors. My name is Jessica McKinney. I'll be arguing for the appellant, Shawnee County.
All right, and for the appellee.
Police Court, Robert E. Duncan II. That's what's on my birth certificate. Everybody knows me as Tuck. I have an older brother named Nip. It's true. I'm a lawyer. I would not lie to you.
And so I'm here, my client is present, and I'm here to argue the case for the appellee.
It's good to have
Ready,
you.
willing, and able.
All right. And Ms. McKinney, do you wish to reserve any time for rebuttal?
I do, Your Honor. I'd like to reserve 5 minutes, please.
That is granted,
Thank you.
and you may begin whenever you're ready.
Thank you. May it please the court. Your Honors, the case before you turns on procedure, whether the Shawnee County Board of County Commissioners, who I'll refer to as the board, followed the correct procedure to raise the revenue neutral rate, to essentially raise property taxes for citizens of Shawnee County. Now, the Board of Tax Appeals, BOTA, as I'll refer to them, determined the board didn't comply with 2 procedures. That decision is wrong as a matter of law. The board checked every box that was required, and I'll discuss those reasons today. So what is the procedure? Well, generally in broad strokes, it requires essentially 4 things. Those are set out in Kansas statute 79-2988. And those procedures are advance notice, a public hearing, a vote at the public hearing, and adoption of the measure by resolution or ordinance. Now, there's no dispute in this case that those first 2 procedures were complied with, the notice and the public hearing. This case turns on whether the board voted at the public hearing and whether it adopted the tax measure by a resolution or ordinance. BOTA wrongfully decided both of those issues. On the vote, it said the board didn't vote at the public hearing because it took a 4-minute break before it voted. BOTA said that 4-minute break was an adjournment, and because the board voted after the break, it voted at a brand new meeting. And with respect to the resolution, BOTA said the board didn't adopt a resolution because it used the word motion, not resolution, when it voted on that matter.
Do we need to get into substantial compliance with the statute to resolve these issues, or is that even necessary?
Your Honor, I think it on these particular issues. So there's no doubt under the statute that the board has to check each of those boxes. Board has to do that, and this board did. But when it comes to the issues before this court, whether the break was a recess or an adjournment, whether how it is you go about adopting a resolution, those are issues that are not specifically spelled out in the statute. The statute doesn't say this is how you go about it. This is how you take a recess. With respect to those particular issues, we have to look at other sources of law. We look at Kansas case law, we look at Robert's rules, which are the parliamentary rules. And under those sources of law, with respect to those issues that aren't spelled out in the statute, substantial compliance really is baked into those issues in the sense that you don't take a break by using a special magic word or following a perfect procedure. You take a break by acting like it's a break. That's what the rules say. And the same is true with respect to a resolution. Kansas case law tells us there's no set or particular form that you have to use in order to adopt a resolution. And so with respect to those issues, it's whether or not what you did looks like a resolution under Kansas law. Does it look like a break under the recess? And here, here the board complied with each requirement. It checked every box that is required under the statute. So turning to the first issue, did the board vote at the public hearing? The answer to that is clearly yes. Now I know you've read the briefs, you're familiar with that, and so I don't plan to go through a recitation of the facts, but I would like to highlight just a few key details that put that break in context and help us understand what that break was. So the public hearing, it was 3 hours, lasted from about 5:30 to about 8:30 in the evening on a Monday night. After some introductions and a couple of speakers, the board opened the public comment segment of the meeting, and that was really the vast majority of the meeting. At least 30 people spoke. Eventually, no one else came forward to speak. The board asked if anybody else wanted to. Nobody did. And it was evident that the public comment segment had come to an end. So the board made a motion to close the R&R hearing. At that point, the meeting had been going on for approximately 3 hours. It was after 8 o'clock, and it was time for a short break. And what did that break look like? It was 4 minutes. During that break, 2 of the commissioners stayed at their seats. They stood up, but they stayed at their seats. And one of the commissioners left for less than 2 minutes and immediately returned. At that point, the board resumed, they voted, and they adjourned the meeting. So the legal question is, what is the significance of that 4-minute break? Was it a recess or was it an adjournment that terminated the meeting? The statute doesn't address that issue. It doesn't distinguish between recesses and adjournments, and neither does Kansas case law. So on that issue, we look to the next best authority, and that's Robert's Rules of Order. Those are the parliamentary procedures that govern the procedures of deliberative bodies like this board. And under Robert's rules, there are really 4 factors that distinguish a recess from an adjournment. Those factors are the duration of the break, dispersion of commissioners during the break, whether there's a declaration of adjournment before the break, and whether there are opening ceremonies after the break. In other words, we look at the context. What is it that the board was doing? What is it that they were trying to do? And we do that because boards are constituted of regular, ordinary lay people. They're not parliamentary scholars. They're not necessarily attorneys. They're serving for their communities in the evenings after their other jobs. So we look, what were they trying to do? What did they accomplish with their actions? And the facts in this case overwhelmingly show that this break was a recess. It was not an adjournment. So the first factor, duration of the break. A break that lasts only a few minutes, that's a hallmark of a recess. And here, this break was 4 minutes after nearly 3 hours. That's a classic recess.
What about the number of people who left? How much of a factor is that?
Your Honor, that's really not a factor at all. Boda misapplied that factor. What the rules look at is what is it that the commissioners did? Where were they? Did they disperse during the break? Did they pack up and leave? If so, that's more like an adjournment. If they stayed nearby, under the rules, that's more like a recess. And here, the commissioners stayed. 2 of them stayed at their seats. 1 left for less than 2 minutes and came back to the seat and resumed the meeting. So it's the whereabouts of the commissioners that matter under the rules, not the whereabouts of the public or the press. And there's a good reason for that. The public or the press, they leave all the time. They show up to, a hearing or whatever occasion it is that they're covering. They get a quote, they get a clip, and they may need to get back to the newsroom to hit a deadline for the evening news, for the morning print. The public, there's no obligation that they stay for the entire 3 hours. The statute doesn't say that. And frankly, they might not want to stay. It's 3 hours on a Monday night. They might want to get back to their family, to their jobs, to any number of different obligations they have. And here, members of the public and the press, they did stay till the very end. We see that on the video. There are members that stayed until the meeting was adjourned. So what they did, what members of the public and press did, whether they came or went, that does not impact the nature of what it is that the commissioners did. It's no different than today. People in this gallery, they may leave at various points during this morning's session. They may leave during my argument, after their argument, but that doesn't affect whether or not this court stands adjourned. This court decides when it stands adjourned, and the same is true for the board. So the second factor is what we've just talked about. It's dispersion of the commissioners that matter. These commissioners stayed, and under that factor, the break was a recess.
How much does it matter that the commissioner's motion actually said to close the public meeting versus we're taking a brief recess? How much does that language matter?
Well, Your Honor, they may not have used the perfect words in the perfect way. But if we look at the context around what happened with that motion, it's clear that that motion was a motion to close the public comment segment. So one of the conclusions that Boda made, it looked at that motion to close and it said, the motion to close is evidence that this meeting was adjourned because the rules don't recognize motions to close. And the only time the term close is used is in connection with an adjournment, but that's just incorrect. The rules do recognize motions to close, and they're just motions that close a certain segment of a meeting. For example, a motion to close debate closes the debate segment, not the whole meeting. And we look at the context of what happened in this meeting, it's clear that the board was using the motion to close in that fashion. So at the beginning of the public comment segment, the board made a motion to open that segment, allowing people from the public to come up to the lectern, to speak, to share their comments. And after everybody spoke who wanted to and no one else came forward, that's when the board made the motion to close the R&R hearing, closing the section that it had opened so we could move on to the next topic. So they may not have used the perfect word, but the rules don't require perfection. Nothing in Kansas law requires perfection. We look at what is it that you are trying to do, what is it that you look like you are doing, and here it was closing that public comment segment so they could move on. The third factor is declaration of adjournment. Under the rules, it says regardless of the type of motion by which you vote to adjourn the meeting isn't closed until it's declared adjourned. Here, there's no dispute. There was no declaration of adjournment before the break. And the fourth factor is opening ceremonies. This looks at whether when after the break, the board performed opening ceremonies, because when you open a new meeting, typically you perform your opening ceremonies. The rules give some examples of opening ceremonies. The evidence shows the opening ceremonies of this board, introductions, welcome statements, Pledge of Allegiance. The board here didn't do any of those things after the break, and so the break looks a lot more like a recess. Turning to the second issue, did the board adopt a resolution or ordinance? The answer to that is yes. Now, BOTA decided this issue. It got this issue wrong, and it said the board didn't adopt a resolution because it used the wrong word. It said motion, not resolution, when it voted. But magic language isn't required in order to pass a resolution. That's just not how the real world works, and it's not what Kansas law requires. The statute doesn't say anything about how you go about passing a resolution. It doesn't require magic language. And when we look at case law expressly rejects that requirement. The Kansas Supreme Court looked at this in Benson versus City of DeSoto. And in that case, the court used the terms motion and resolution, the very terms that BOTA was hung up on in this case, interchangeably. They're the same thing. But even more important than that, the Benson case rejected BOTA's conclusion that a resolution has to be in some magic form or has to use some special language. It said that resolutions don't need to be in any set or particular form. They can be verbal. They can be reduced to writing at a later date. And all they are is an expression of the opinion of the governing body. The same is true under the rules. They don't require special or magic language. And in fact, they say small boards like this board here, they're granted greater flexibility, greater leeway, greater informality in the procedures that they use, which of course includes the adoption of resolutions. So this board here, it adopted a resolution exactly as described by the Benson case. It adopted a verbal resolution at the public hearing, and it later reduced that to writing just 3 days later on August 24th. A final point on the resolution issue. Mr. Corbett has argued on appeal that the statute requires a written resolution at the public hearing, but there's no support for that position. The statute doesn't require a written resolution. If the legislature intended that, it would have said that in the statute with the same specificity that it's used for other actions required under the statute, and it didn't. And several sources reject that idea. We've talked about the Benson case. That's the most important one. It says no particular form is required for a resolution, and it allows the board to adopt a resolution exactly as it did in this case. So with that, I'll reserve the rest of my time for rebuttal.
Thank you.
Thank you.
Please, the court. So little time, so much to say. I was going to give you the AI executive summary, but I didn't use my chat this morning, so I'm going to have to give you my handwritten presentation. The case concerns a taxpayer challenge to the Shawnee County Board of Commissioners' decision to exceed the revenue neutral rate for 2024. As the Board of Tax Appeals correctly determined, the Board of Commissioners failed to follow the statutory procedures set out in 79-2988B4 when it acted at its August 21st, 23 public hearing. First thing I'd like to say is I don't think they've met their burden. Under the standard of this case, we're here on a appeal from the Judicial Review Act. And the Judicial Review Act sets out all sorts of things that the court has to look at with regard to whether or not to overturn the Board of Tax Appeals determinations. I read one case on which Judge Malone wrote an opinion with regard to the board and the issues of whether or not there had been meeting that burden to determine that there was not substantial competent evidence, even if the court didn't agree with the decision. If the Board of Tax Appeals found substantial competent evidence to underlie the decision that it's made, you're obligated to affirm that in my judgment. So we've got a real first issue is there really anything to look at? You look at the BOTA's order, and then you make a determination. Given the ambiguity in the usage of the term closed by Commissioner Cook, the board reviews the context in which the motion was made and the activity that occurred thereafter. Here, the motion to close was made at the end of the public comment period. Thereafter, both the video of the proceedings and the written and oral testimony presented indicate the members of the public and press in the room began exiting the meeting. So what was the play-by-play? If you review the videos, and there's support for you to look at all the videos, and they're part of the record, and I would encourage you to do that. There's actually two videos. One video, the security video, has no audio. But you got to look at the YouTube video to hear the audio and to read the transcript that YouTube gives you. But if you do that, you're going to find that Commissioner Rippon at 2:49:47 started communicating with the public and said, your thoughts, but I just want to let you know there's other people out there digging into the same dollar. So, and then there was an unrecognizable audience statement. And then the commissioner said, well, there you go. I think we have to vote to end the meeting. I think we have to vote to end the meeting, he said. Unknown voice states, close the public hearing. Then Cynthia Beck, County Clerk, states, closing the R&R hearing. Commissioner Cook, motion to close the R&R hearing. Rippon, laughing, thank you with the better ears. Rippon then says, motion has been made by Commissioner Cook, seconded by Commissioner Mays. All in favor say aye. Those opposed, motion carries 3-0. And importantly, for the public, the commissioner then wraps his gavel. They're gone. They're out of there. He wrapped his gavel. They're gone.
The staff was trying to tell the commissioner what words to use. Right?
Yes, but he wasn't prepared. That's the sad thing about this. The officials acted inconsistently with the statutory requirements. The public deserves better attention to statutory compliance. This was a clear example of government error that must be addressed. The record clearly supports BOTA's conclusions that the board did not vote at, quote, at the public hearing as required. They closed the public hearing. They weren't at it. It was over, gone, done. And then under
significant, counsel, that the commissioners specifically moved to open public comment. And so then they needed to naturally move to close that public comment.
They don't have to close the public comment. The other problem with their whole argument is they want you to say they substantially complied with the statute. This is not a statute for substantial compliance. This is a statute to be strictly adhered to. And how do we know that? Because we have several cases which I've cited, but in addition, we know that because the law provides that the the statute says 79-2988, no tax rate in excess of the revenue neutral rate shall be levied by the governing body unless a resolution or ordinance has been approved by the governing body according to the following procedure. They didn't do that. This isn't well, we want you to sort of do this. It's, you must do it this way. Then you go down to B4. A majority vote of the governing body by the adoption of a resolution or ordinance to exceed the revenue neutral rate is required. Not suggested, it's required. And they didn't do that. And it's not to be substantially complied with. We need to strictly follow the statute. And that's what, that's in plain language. They have to comply with the express requirements. Contrary to their repeated assertions, the record demonstrates that the board failed to meet both statutory conditions necessary to exceed the revenue neutral rate. They have to have the vote at the public hearing, and they have to adopt it by a resolution and ordinance. I find it interesting that if they did it so correctly, why did they find it necessary on April 24 to go ahead and pass it again? And on that occasion, they passed it in the written. And they even said in item number 2 on their minutes, Commissioner Mays moved approval of resolution number 23-56, exceeding the revenue neutral rate in its property tax levy for the budget year 2024. They actually did it 3 days late. And they couldn't have passed it on the day because their own rules first say that they're supposed to have a resolution. They keep arguing Robert's Rules of Order should, and there's no statutory requirement. No, there's no statutory requirement. There is a county requirement. They've passed their own rules on how to conduct themselves. And those rules say they will have a written resolution. It will be submitted 5 days in advance. It will be on the agenda. There was not even an agenda for this meeting. All there was a single page that said, we're having a meeting. That's it.
Let me interrupt you.
Oh, yes, sir, please.
On the vote.
Uh-huh.
Does it matter what they called it, i.e. a motion, or is it more important how they voted? Because they did conduct a roll call vote, which is akin to a resolution, as opposed to a voice vote, which is akin to a motion.
Well, they finally got to a roll call vote because the first one at the new meeting was all in favor, say aye. And then the clerk or the attorney, I forget which, said, oh, you got to do it by roll call. So the commissioners had no friggin' idea what they were supposed to be doing. They didn't know they had to do a roll call vote. Finally, the staff said roll call vote, and they did it. It makes a difference because the legislature specifically wrote it that way. Senator Tyson's committee wrote it this way. This bill was enacted in a very short period of time. It had a hearing in January, and it was law by March of that year when it was first proposed for transparency. It's very strict. You follow it. You do it exactly the way it says it. And so, yes, both are important, but you can't just say we substantially complied because we had a roll call vote. They didn't have a vote on a resolution that wasn't approved until the county councilor approved it on 8/21 of 23, and it wasn't even before him. The first time they saw it was on the 24th when they voted on it. It is important because this resolution conforms with their own rules, and they ignored their own rules. And Robert's Rules of Order only apply at the Shawnee County level if there is no county rule on how to adopt a resolution. So all this discussion about whether there's state law or on how to do it is totally immaterial. I had cataract surgery, so I can't see far and close at the same time. Apologize. Okay, so what happens? Under this, you have to give notice. They gave notice. You have to have a hearing. They had a hearing. And then there's you have to have the vote at the public hearing by the resolution, and there's consequences for not doing it that way. And what's the consequence? The consequence is that the taxpayer can file as Mr. Corbett did, and the board, if it finds they violated the statute, can order refunds of the excess taxes collected, which is what the board has done in this case. Now, let me very quickly talk about what if the break was an adjournment and not a recess. They claim that the 4-minute break constituted a recess, and that's unsubstantiated by any contemporaneous statement, motion, or entry in the record. If you look at the tape, you're going to find that Commissioner Cook took all of his files and put them in his big file folder and eventually was putting them into his briefcase. The attorney had everything in his briefcase and started to walk away from the table. So don't tell me that he still thought they were in a meeting. He had his briefcase in hand as he was arguing with Senator Tyson about what the procedure should be at that point in time. And then the only person who actually stayed put and did nothing was the county clerk. Commissioner Mays packed up all his stuff. He had all of his stuff in his folder. And then he walked out for a couple of minutes, I presume to the restroom. I don't know that for a fact, but he walked out and he came back. And then, and the only reason Commissioner Rapon was there was because he was having these arguments with Senator Tyson at the same time. And you know what the factual record is? Senator Tyson was there telling him, you haven't done this right, folks. You have not voted during the hearing. And that's the only reason they came back and then had a motion to resume so they could vote in some effort to try to substantially comply. Substantial compliance does not take care of it. This is to be strictly complied with, and that's what the court should order. But irrespective of all that, they still haven't given you justification for why you should find that the board's order was arbitrary or capricious or was not supported by substantial evidence. And I think you've got to get through that threshold first, because if you don't get through that threshold, there's nothing else to talk about. And you affirm their order, and we move on down the pike, and they have to refund to the taxpayers, to Shawnee County, the lucre that was illegally taken from them during that tax year. They want to tell you that witness testimony and public observations are irrelevant. Well, they're not. The board's suggestion that testimony ignores that the official record and the conduct observed by the public. People left in droves.
Well, now, there is a video.
There is.
And there's still photos.
Yes.
And you can actually count the people who left.
And there's about half of the people are still there.
I think there were 26 before the break. I'll call it a break. And then there were 15.
I object to that language suggestion.
You're arguing whether it was a recess, so I won't use that word. So in other words, people left, but I'm not sure if it's correct to call it they left in droves. Most of the people stayed, a little bit more than half.
Well, a number of those and you are staff people. They're not all public people. So you have to take that into account when you're looking at that video and those pictures. But irrespective, let's assume for a minute that the meeting wasn't adjourned, just for sake of argument. I don't agree with that, and the board doesn't agree with that. The board says, and I think you need to follow what the board said. But let's go to the next question about the resolution or the ordinance.
Well, I mean,
they didn't do that.
Is there any member of the public who didn't get to speak their say that evening?
I don't know. I was not there.
Well, we have a video of it.
Well, we have a video that shows they had 3 hours of time to.
And after 30 people talked, they said, does anyone else want to speak? And no one came forward. Is that important?
Well, it's important to know that it's now time to vote. That's when they should have taken the vote. Does anyone, Commissioner Rapon decided he was going to give a little speech about, there's you and there's others, and kind of justify what I think he already probably knew in his head was his vote going to be. And then as a result of that, then they should have voted. They should have had a resolution, and they should have put the resolution up and said, I move that we adopt resolution 24, whatever it is. And by roll call, yay, yay, yay. And had they been properly prepared, they would have had a script. They would have had a script that told them exactly what they needed to do, but they were very lackadaisical about the whole process. Very lackadaisical. Their lawyer didn't seem to advise them as to what the process was going to be until the very end. He chimed up and said, and the county clerk's the only one who said, close the revenue neutral hearing. But they shouldn't have even closed it. They should have taken the vote at the public hearing. That's strictly construed. That's what the statute says. Take the vote on the resolution at the public hearing. I don't see how you get around that. I just don't, Your Honor. You could fudge it, but they didn't do it. And these are serious consequences, and I'm sorry for it. But the conclusions of the trier of fact should be given deference per the Judicial Review Act.
The factual conclusions.
I'm sorry, I didn't understand.
To the extent that Boda made findings of fact,
Right.
they must be supported by substantial competent evidence.
It was.
Their legal conclusions we review de novo without any deference to Boda. Isn't that correct?
Well, I made some notes early this morning on that. I think that In re Brebe indicates, that's 47 Kansas Act, second 122, that the order just has to be not so wide of the mark, quote, end quote. And was the evidence substantial? We had lots of testimony from various people that were present there. There was no real rebuttal to any of that testimony of the persons who were present and made the observations. And again, the burden is on the party asserting that the order shouldn't be followed. Now, what legal conclusions did they make? You have to have a factual conclusion first in order to apply the law. And their factual conclusions are substantial, and their determination was they did not follow the statute. Now, that's true if you interpret it as strict compliance. If you want to go with their, hey, it's okay to fudge it, and we just have to have substantial compliance, and we don't have to do it exactly the way the statute says, well, maybe you can overrule what Boda said, but that's not what the law is. The law is, if the statute is clear on its face, if there's no real in determining whether a provision is mandatory or directory, general rule is that where strict compliance with the provisions is essential to the preservation of the rights of the parties affected and the validity of the proceeding, the provision is mandatory. That's Paul versus City of Manhattan, 212 Kansas 381. There's others I can cite in a letter after this hearing. The point is, it's strict construction. And so Boda got it right. They got it absolutely right. The other reason I believe that to be true, 2 minutes, 2-minute warning, is because, here's my little notes. Pardon me, Your Honor. The appellant wants you to reverse the Boda's decision because they said that it was okay, substantially complied with. They're wrong about the rule on recessing. There is a statute that does talk about that does make it clear that there is a process by which you do declare recess. It's in the executive session statute of the law, and I'm sorry I can't cite it to you right at this moment. And so there is some guidance on how you do a motion to recess and what you call it. And that was not followed either. So the bottom line is, Your Honor, I don't want to belabor this point too much, except to say we are entitled to our refund. We are entitled to having the county commission do its work in the manner in which the legislature told Shawnee County and the other 104 counties and all of the multiple cities to do it. And amazingly enough, everybody else seemed to have gotten it right. Because as far as I know, this is the only taxpayer challenge that occurred before the Board of Tax Appeals. And so it seems to me that you should uphold the board. They have not met their burden. And I appreciate the opportunity to appear before you today and to be the first to sit in your brand new chairs.
Thank you. Counsel. Let me start off with a question. This matter of having the written resolution at the hearing, all typed up and ready to go. Do they ever do it that way or?
In terms of just any meeting that the board has?
Any resolution to exceed the revenue neutral rate?
Well, there wasn't a resolution that was typed up at this meeting. It's not required. Benson tells us that's not required and it's not necessary to have a written resolution there. At other meetings, regular sessions of the board, there are resolutions that are prepared in advance. But that doesn't impact the question that's before the court today. It's not necessary to have a written resolution. Like I said, Benson says that nothing in this statute that sets out the procedure requires that. And also this meeting is different. This is a public comment meeting. The purpose of the meeting is to have members of the public come to this meeting to offer their public comments. And it's possible that what the members of the public say may persuade the board to do something different. It may persuade them off of the intent that they had coming in. And so there isn't it isn't necessary to have a written resolution written out. They may change their mind during the course of the public hearing while they're listening to the public comments and decide, you know, they're going to do something different. They're going to deviate from the original intent that they had coming in. So
Do the county rules require it?
they do not. No, the county rules do not. We heard about the county code provisions, but those code provisions, when we look at them, and I don't have the section directly in front of me, I can grab it for you, but they say that they do not apply to resolutions that pertain to tax measures. So number one, those code provisions don't apply to the issue that's before this court. Even if they did, it doesn't change the outcome. Nothing in those code provisions says there has to be a written resolution at the public hearing. They set some administrative parameters for resolutions. They say, you know, they need to be signed, they need to have a number on them, things like that. But the board complied with those. It followed what Benson allows, that you can adopt it verbally and you can later reduce it to writing. That's what the board did here. That's allowed by Kansas law. And there's nothing that precludes that within any of the county code provisions or anything else. The only time, just on that point, the only time that the statute says, the statute that's before this court that governs this procedure, the only time it says that there needs to be a resolution in writing is after the board has adopted the budget. Once it's adopted the budget, it packages the budget, some other budget papers, a copy of the resolution, it gives that to the clerk. There's no dispute in this case that the board complied with that. It did reduce its resolution to writing, gave it to the court as to the clerk, just as it was supposed to, and it followed what was required under Kansas law when we look at the statute and when we look at the case law on that issue. The board here, it fully complied with every provision of the statute. It checked every box. It had advance notice, it had the public hearing, it voted at that public hearing, and it complied a resolution as we've talked about. Now,
So to be clear, you're saying that you win even if we require actual compliance with the statute as opposed to substantial compliance. You still argue that you were.
that is correct. Yes. Yeah. Under either standard that the court applies, we followed exactly what the statute requires. We went through every procedure that was required and we checked every box that was required. Now, the arguments that we just heard on behalf of the taxpayer, it's interesting. They ignore the law that governed the issues before this case. They argued that Robert's rules apply to the issues that are in front of this case, to BOTA. And now they're saying, well, they really don't matter that much and you don't look at them. We didn't hear any analysis of the factors under Robert's rules that tell us what the difference between an adjournment and a break is. And they don't address the Benson case either. We haven't heard why it is that that case doesn't control what it is that a resolution is and how it is that you go about adopting it. And it's because those two bodies of law, the law that governs these issues, they are dispositive in favor of what the board did here. That's why we don't hear any argument addressing those. This court is exactly right. It talked about the roll call vote. Is the roll call vote a resolution? Yes, it is. It is a more formal vote than was taken on any other measure that was before the board that night. It was a roll call vote. It required for the clerk to read the roll and to record the vote, for each individual commissioner to state the vote, and then for that to be certified. That was done. It was formal. It was a resolution. So Boda's decision, it's wrong as a matter of law. Its requirements for perfect parliamentary performance are unreasonable. They're contrary to Kansas law. They're contrary to the rules. And we'd ask this court to reverse the decision of Boda.
All right, counsel, thank you very much for your briefs and your arguments. Interesting case.
Thank you.
We will get an opinion out to you just as soon as we can.
Thank you.
The next case that was on the docket was the estate of Richard Deal, and it was dismissed. I presume no one is here for that, which brings us to the only other case this morning, which is out of Anderson County. It's number 128399, the state of Kansas versus Michael Tate Presley.
Judge Malone, I think Mr. Aislinger may have stepped out, perhaps overstimulated by the last argument. So take a look for him real quick.
All right.
Chris. Other case, that's all right. Thank you.
We have Mr. Dunn here for Mr. Presley, Aislinger here for the state.
Yes, Your Honor.
I know you're both frequent flyers, so let's just get right to it. Mr. Dunn, do you wish to reserve any time for rebuttal?
Yes, Judge Malone, could I have 4 minutes today, please?
That is granted.
And as I hope the rules still apply from back in the day when Judge Perrin used to say you don't have to use all your time and we won't penalize you if you don't.
We definitely will not.
Okay. I'm hoping I won't take up my total time today. My main purpose today is to clarify my brief because in light of the state's response, I think the issue is a little muddled. The issue here is what crime is proven by a no contest plea. The answer to that question we think is pretty simple and governed by statute. The crime proven is the crime alleged. The crime proven is the crime alleged in the charging document. Nothing more, nothing less. The reason why I think that's important to clarify today is because the state's response answered the wrong question. The state skipped over the question of what crime was proven and simply assumed that the crime proven in this case was the Jessicas Law version of ag indecent liberties.
You're not arguing defective complaint, right?
We are not arguing a defective complaint. The complaint was perfectly fine. If we look at Dunn, all you have to do is allege facts that constitute a crime. The facts alleged in the complaint in this case definitely constituted a crime. So we don't have any jurisdictional problem or anything like that. The question is, what was the crime?
And don't we look to the factual basis?
No. That's the next step. First, you have what crime is charged, and that's under, we look at by a no contest plea, that's governed by 223209(2). Just like in 223209, it tells you the effect of a not guilty plea and the effect of a guilty plea. These are different things, all three are different things. But under 223209(2), plea of no low contendere, no contest, is a formal declaration that the defendant does not contest the charge. So what is the charge? The charge isn't the factual basis of the plea. The charge is what's in the charging document. That's why it's called the charge. So we're not looking at, and this is where the problem is, and I got to issue a mea culpa, I should never have mentioned 223210, which is the factual, subsection A4 is the factual basis part. I think I muddied the waters even mentioning that in this case, because it's not relevant to what crime is charged. That's a different question. A judge can only take a plea if there's a factual basis. But you still have to get to the initial question, what's the crime? And I think an easy way to look at this and a better way to clear this up is to think about it this way. Say we have a defendant who shoots a victim with a gun and they cause great bodily harm. Now, state charges that person with level 4 aggravated battery. Question, however, exists as to self-defense. Now, we go to preliminary hearing, judge doesn't find self-defense immunity. So now the parties were bound over on level 4 aggravated battery. Parties reach a plea agreement because now the jury, the witnesses aren't so great. So I'll tell you what, state says, we'll give you, how about you plead to simple battery? Defendant says, you know what, I don't want to roll the dice, we'll take that plea. So at sentencing, no one would think that after you plead to simple battery, that the district court could then sentence you to level 4 aggravated battery. And that's what we have here. The exact same thing. We have the charging document. Where the facts in the charging document are aggravated indecent liberties with a child, non-Jessica's Law version, because there's no age in it. We don't look at the fact, we're not talking factual basis here.
Why?
And I know.
Okay, maybe you don't want to talk about it, but I kind of do. Why did the judge even ask for a factual basis?
Because in every case, the judge has to have a factual basis.
Right. And they wouldn't have found your client guilty of anything without a factual basis, correct?
Sure. And there was we are not disputing that there was a factual basis given that supported non-Jessica's Law aggravated indecent liberties. I mean, the only way you get to, the state can even get to there being a Jessica's Law is to read between the lines from the preliminary hearing. That's the only time, and that's based on, the state admits, no one ever said his age, ever, below. You can only get to that through inferences. So we certainly, there's no question, we have a factual basis for non-Jessica's Law aggravated indecent liberties. There's not a problem with the factual basis here. What we have is, what crime was the conviction for? And that crime was what was in the charging document, and by lacking an age in there, the only crime from those facts is and I keep wanting to say simple aggravated indecent liberties, but that's not really a thing, is non-Jessica's Law, sorry, that's the only thing I could think of to call it, aggravated indecent liberties with a child. Now, I point out that that's not the way the cases cited by the state. All of them have to do with one of two things that aren't on point or related to this issue. Look at Marler, that was a Jessica's Law case where the jury instructions had a finding. We have Callaway, which was a manufacturer case, which apparently it was within 1,000 feet. The jury had the actual necessary factual findings in the instructions. And then Provo was a bench trial case where the judge found the age. Now, these are different. Jury trials and bench trials are different things. They're not the same thing as a plea, and by plea, I mean a guilty plea or a no contest plea, because different facts come out and the jury makes these factual findings. So we have a specific statute that says guilty pleas and no contest pleas are tied to the complaint. That's different than a jury trial or a bench trial, because there is evidence and you can look to that evidence as to what was the crime proven. Now, the other cases left by the state, remaining by the state, are all factual basis cases. The case, the chart in Easterling, the charging document had the age in it. In Gomez, both the original and the amended charges listed the age of the defendant. In Longbine, it was a defective complaint case, but that actually listed his age in the caption. So all of those cases are looking at different things than what we have here. They're not looking at what was the actual crime of conviction. And the crime of conviction, again, is what was in the charging document. It's as simple as that. So the crime of conviction in this case was non-Jessica's Law, aggravated indecent liberties, just like in my hypothetical, the crime of conviction is a battery. And the judge cannot go beyond what the crime of conviction to impose a different sentence. So for those reasons, we'd ask this court to reverse and remand with instructions to impose a sentence for non-Jessica's Law, aggravated indecent liberties with a child. Took a little longer than I thought, sorry.
May it please the court, Chris Elslager appearing on behalf of the state. And, I have to profess, obviously our take on the issues is a little bit different. From the beginning, we understood his argument, basically believed that there was no proof that he was over the age of 18. And now oral argument, it's morphed a little bit into he didn't understand or that he wasn't charged with an off-grid crime. But the complaint did charge the proper statute as an off-grid crime. And I pulled up the plea hearing, and let's see, that's record volume 5. And the judge says on page 5, the judge says to the defendant, "Have you had sufficient opportunity to review this complaint and discuss that with your attorney?" The defendant answers, "Yes, sir." And the court says, "You understand that count number 1 charges you with aggravated indecent liberties with a child, and under the laws of Kansas at this time, that is an off-grid person felony. Do you understand that?" The defendant responds, "Yes, sir." The court then says, "You understand what it means that it's an off-grid person felony?" Defendant, "Yes, sir." "What does that mean to you? What is your understanding of that?" Defendant says, "It doesn't fall under the grid that he showed me." The court then says, "The grid that I'm holding up, the sentencing guideline grid, you understand it's not on the grid?" Defendant, "Yes, sir." The court says, "You understand the penalty is life imprisonment with the first chance of parole in 25 years. The defendant, "Yes, sir." Court, "Do you understand that?" Defendant, "Yes, sir." And it goes on, and then eventually, of course, the court says, "With that in mind, you still want to go ahead and enter no contest plea to this count?" "Yes, sir." So it's clear that the court, the defendant, all the attorneys, all understood that the defendant here was pleading guilty to a Jessica's Law crime. He's not arguing that the complaint was defective. It charged the right statute. Everybody understood it. There's no surprise, and I think there's a litany of cases cited in our brief that essentially say that even if there are minor errors in following the process of entering a plea, that's a technicality. That doesn't, the defendant doesn't get to play gotcha with that and suddenly get his sentence that he knew he was going to get sentenced to cut down to a mere matter of months. There was no confusion or misunderstanding on the part of the defendant here. He fully understood what he was pleading to. He knowingly and voluntarily entered his plea. I don't know what more to say to that. Obviously, the brief focused a lot on the facts and the inferences that can be drawn from them that he was clearly 18 years old. I mean, the victim was his daughter, who I believe was 13 at the time, and we don't need to be a doctor to know that toddlers don't father children. So he had to be clearly over the age of 18. He was also a commercial truck driver, so he had a commercial driver's license. And then you look at, eventually we know from the pre-sentencing report that he was 38 years old. And he's not arguing that he wasn't over 18. He can't make that argument. So clearly there was sufficient facts in the preliminary hearing, which the court relied on as the factual basis to establish that he was over 18. He clearly knowingly understood what he was pleading to. That's clear from the record. So I'm not quite sure what his complaint is now. So I would simply ask the court to affirm the lower court.
State's argument sounds to me like they're arguing a notice issue. And that's not what we're here today on. We're here today on what was the crime of conviction. There was never, nor was this a voluntariness argument I'm having right now at all either, nor a defective complaint problem. There was never an amendment to the complaint here. The only complaint before the court lacked the necessary element to make it a Jessica's Law case. Nowhere on the complaint, it's a simple piece of paper you can look, is anything saying he was over the age of 18 years. And I'd point out, the last thing I want to point out is people agree to lesser crimes all the time to reach things, and those aren't illegal. You can plead to a non-Jessica's Law case, even though it may be, the facts may present to a Jessica's Law case. That doesn't matter. The thing is that, and that's perhaps why we have these pleas, because to say you have a judge that's a wild card, every other judge in the district, probably follow the plea agreement, but you have another judge that is a wild card, and the parties may decide, okay, we're going to reach an agreement to enter a plea to this particular conviction so we can box the judge in, is stuck with the guideline sentence or whatever. If it's a particular off-grid and non-consecutive thing, we're going to dismiss the 2 or 3 other counts, so there will only be 1 life sentence, whatever the case may be. But people plead to crimes that aren't necessarily what the underlying facts are.
Is the argument you're making today somewhere in the 7-page brief that you
Yes.
submitted?
That's why I talk about 3209. I said mea culpa, I should not have mentioned, when I mentioned 3210, that was simply to make the point that nowhere was his age ever mentioned, period. But all it comes down to is what crime was he convicted of? And again, perhaps I was not as clear as I should have been, and I should have only had a 2-page brief saying as much. I have a habit perhaps of speaking too much. But it's as simple as that. What crime was he convicted of? And this was the crime he was convicted of, was non-Jessica's law, aggravated indecent. Unless there's no further questions, I'd ask the court to reverse. Thank you.
All right, counsel, thank you for your briefs and your arguments. We'll get something out to you just as soon as we can. And with that, that completes this morning's hearings. We'll reconvene at 1:30 this afternoon.